Hello everyone, this is second video as relating to constitutional law 2 subject, and this is the second question: freedom of trade, commerce and intercourse within the territory of India. It includes the article 301 to 307. Before I am starting this concept, you know about the article 19(1) of the constitution. What it speaks: all citizens have right to practice any profession, occupation or trade or business in India. So, Article 301 speaks: Indian Constitution declares that the trade, commerce and intercourse throughout the territory of India shall be free. So, it includes the word trade, commerce and intercourse. What it means to see one by one. First one, trade. It means in generally buying or selling of goods for a profit. Under Article 301, what it means: trade, an actual, organized and structured activity with a definite purpose. It is called as trade. And what it means: commerce. It means transportation of such a goods through the land, air or water is called as commerce. And what it means: intercourse. It means movement of the goods from one place to another place. These three concepts are clear in Article 301, which includes the trade, commerce and intercourse throughout the territory of India shall be free. So, as relating to 301, the case laws are State of Bombay versus RMDC. In this case, Supreme Court clearly held that gambling is not a trade under Article 301 of the Constitution. So, impliedly, you know, trade means the buying or selling of goods, not a gambling is included in the trade, so which is called as a trade. And second one, Pechand versus State of Maharashtra. In this case, Supreme Court held that money lending is not a trade but it is a business under Article 301 of the Constitution. So the next concept, Article 302, which is clearly speaks about the power of the parliament to imposing some restrictions on the trade, commerce and intercourse, which is to carry on within the state or across the state, anywhere in the territory of India, to carrying on the trade, business or intercourses. So, in these concepts, the power of parliament to imposing some restrictions. The next, Article 303, some restrictions on legislative powers of the union and state with regard to the trade and commerce. So, some restrictions are based on these concepts on legislative powers. It categorized two clauses. 303 subclause 1 speaks about the parliament shall not have power. The parliament shall not have power to make any law giving any preference to any state to over another state by virtue of any entry relating to the trade or commerce. So this is a clause speaks about the parliament has not power to trade, commerce as relating to the states, which is not interpair of the parliament. So the second clause, 303 subclause 2, it speaks about the purpose of dealing with a situation arising from a scarcity of goods in any part of the territory of India. So you know, Article 304, restrictions on trade, commerce among the states, which is particularly states, whatever the restrictions are imposed as relating to the trade, commerce and intercourse, which categorized into two clauses. Clause A speaks about without tax discrimination between the goods importing and manufacturing or produced in a state. So it speaks in some important judgments. In one of the case, State of MP versus Bailal Bai. In this case, state of MP to importing the tax on tobacco, so which is not even a subject to the tax, but the court clearly held that the disapproved of tax statements that it was discriminatory in nature. So the next one is subclause 304b speaks about the authorizes of the states to imposing the states such a reasonable restrictions on a freedom of trade, commerce and business, which is particularly relating to the states to imposing of the whatever the taxes as relating to the trade, commerce and business. So it must be in the public interest. It must be in the public interest as well as the president approval is necessary. Whatever the law making as relating to the trade, commerce and intercourse from any state, consent of the president is necessary. So the next concept, Article 305 speaks about saving of existing clause. The word itself held that existing clause must be saved. So in the circumstances of operation of any laws which is not be overriding the article 19(1)g of the provisions, so it will not overriding of that any operating laws, so it must be saved in this clause. So article 306 will be abolished, and article 307 amendment of authority for carrying out the purposes of article 301 to 304, which is the amendment clause. The parliament must confer such powers and duties if it necessary circumstances only. As regard to the article 307 as well as other articles as relating to some landmark judgments, one of the landmark judgment is Achyabari Tea Company versus State of Assam. In this case, the petitioner carrying on the business for the purpose of transporting of the tea to Calcutta through the Assam state. But in the issues are framed as relating to this concept. The first one is whether it violate article 301 or not, and the tea was liable to tax under the Assam Tax Act 1954. So the judgment is like this. Supreme Court held that it's a legal tax. There is a no illegal or improper conduct by the Assam State Taxing Act under Article 301 of the Constitution. So it is a valid tax by the Assam state as relating to the transport of the tea through the Assam state to Calcutta. So another landmark judgment is State of Mysore versus Sanjeevia. In this case, the Mysore Forest Act 1900 made the laws as relating to the banning of the movement of forest produce between the sunrise and sunset. So issues are framing like this: it violates the article 301 or not. These issues will be as relating to the only the forest produce between the sunrise and sunset, so it violates the article 301 or not. The judgment is like this. Supreme Court held that the Forest Act is void because it remarked that such laws are restrictive and not regulatory, so it violating the article 301 of the Constitution. So these case laws are as relating to the trade, commerce and intercourse of the Indian Constitution as relating to the article 301 to 307 of the Constitution. Thank you.